Our next panel is on post-acquittal criminal records, an oxymoron. We've got a great panel. We've got Scott Cowan in the middle, virtue in the middle, said the devil as he sat between two lawyers. Scott, for those of you who, well, you may know Scott as, in addition to being a fantastic criminal lawyer, does work as a stand-up comic in his spare time and is one of the top 3 comedians on this panel. You've also got Sean Dewart, who is primarily a civil litigator, who has appeared at every level of court, including on behalf of interveners at the Supreme Court of Canada and frequently at the Court of Appeal, where he's had a great deal of success. He also, I know he used to do a lot of defense work for lawyers, so there's a big stack of his cards outside. And finally, of course, the man that needs no introduction, who commits to baseball themes whenever he can, John Struthers, who, when you play the game, if you got charged with murder, who would you hire, is always at the top of everyone's list. So with that said, please take it away, guys.
Gee, thanks.
Good morning. I think this is a topic everyone will like. It's about cases that you've already won. And it's something that I was sort of worried when drafting it that I'd be accused of this being overly histrionic or overly paranoid that the rule of law is under attack and the presumption of innocence is meaningless. But I have to tell you, I really am concerned by what we've seen in a few cases we're going to talk about today. And that is the lingering effect of a criminal charge that was disposed of one way or another, basically favorably for you. Cases you call wins, cases your client shakes your hand and thanks you for all your hard work and for getting the great result, and cases that you put, quite frankly, a lot of work into to get that result, whether it's convincing a judge to give a discharge, or convincing a Crown to withdraw something, or selling a Crown on a diversion plan, or some other non-criminal disposition. I mentioned discharges, they're a bit separate, but peace bonds, of course, and withdrawals, acquittals, and they have different consequences, each one, for the post-win period. And it should be no surprise to you, having you all, I'm sure, are aware of the results of the Privacy Commissioner's report into the juror background checks, that the police retain a tremendous amount of information about disposed of charges, things that weren't charges. Remember in that thing there was evidence that this guy doesn't like cats and his dad is a drinker. Remarkably esoteric information that the police retain. When you get your client's disclosure brief at the back, there's always those 3 or 4 pages of sort of editorializing caution violent, caution suicide risk, caution hates police, sort of this soft evidence that doesn't really have any basis or any real evidentiary foundation disclosed to you. And it exists out there, and it's so easily ascertainable because what we'll call the Googleability of this information. You can pull it up in 2 seconds. It used to be that if you had a conviction from 1975 for possession of marijuana, it was probably destroyed by now, completely gone. There'd be just really no record of it. Now, the ability to retain and search information is so amazing for the police that they can just keep everything and then pull it up at a moment's notice when someone comes calling. So today, I wanted to talk about a special type of client, and that is the client who has a very bright future. And it's a privilege to represent these people that are going into nursing, policing, law, and I don't want to make a hierarchy of your clients, but I act for people sometimes that are in professions, people that have high security clearance at the nuclear facility near where I work, and I also represent chicken catchers and truckers who do short haul and don't really care about a criminal record, I don't want to create a hierarchy, but the fact is different clients have different things at stake. And this class of client, the future teacher, doctor, lawyer, nurse, engineer, any governed profession, someone who wants to have access to firearms, people that have outside interests, obviously, to the criminal charges, that the stigma of the charge itself or even the acquittal, withdrawal, peace bond can have this lingering effect. And the Canadian Civil Liberties Association did a paper last year on the disclosure of non-conviction records. And they studied essentially stats from Alberta, but the point was very troubling, that people who were acquitted or the subject of withdrawn charges were failing what were called vulnerable sector checks and other kinds of background checks on some unmeasurable, from the defense lawyer advising their clients, position, unmeasurable standard of what makes someone fail a background check. Oh, he has domestic violence allegations in the past. He's a violent person, even though they were all withdrawn or acquitted. Oh, he was charged with a sexual offense and therefore can't work anywhere near children. And these kinds of facts and conclusions that the CCLA report concluded, they said what I just said at the beginning, that this is an attack on the presumption of innocence and possibly an attack on the rule of law, and makes what we do, it's so chilling, because how much time have you spent drafting that letter to the Crown saying, please withdraw this charge? How much time have you spent reviewing a file and writing a letter on the weaknesses in a Crown case, and you tell your client, I'm going to get you a great result, it's going to be withdrawn? And how many times have the client asked you, will I have a criminal record after this? And you can say, no, you won't, but you're maybe wrong. Because there will be and I hate these air quotes, but there will be a record of the charge, and it will be retained, and it will be accessible. And we're going to talk about some cases where that happened today. And the first one I'm going to start with is a case called JN, which was an application to quash a police decision to release information about an assault charge. And I was counsel for her at the criminal matter, where she was charged with assaulting with a weapon her 91-year-old father. She was sweeping under the table in the kitchen and hit his leg, and he went to see other siblings of hers later in the year and told them that she's mean to me, and one time she hit me in the leg with a broom, and she was charged with assault with a weapon. And the Crown offered a peace bond. She said, I cannot accept a peace bond. I can't possibly ever agree in a court that my father fears for his safety from me. And we set it for trial. And on the morning of trial, the Crown, I'd provided them with some information about the fact that they were fighting over a huge estate and that there was other reasons to doubt the complaints, and they withdrew. They didn't have a problem with it. They were like, yeah, this is a stupid case. I'm sure everyone here has had their stupid cases. It was a stupid criminal case. And so she's thrilled. We walk out of the courtroom as winners. And then she applies for a job with the Catholic School Board. And as a media relations person, she was trained as a journalist. And she fails a vulnerable sector check. They're going to disclose her assault with a weapon charge. So she calls me up, and I called the police and said, well, why would you do that? The charge was withdrawn. She said, well, we don't know why. Maybe she threatened the victim and didn't come to court. They said, well, maybe you won an 11B. And I'm like, I've never won an 11B. and at this point, I'm sort of flummoxed. I write to them and say, why are you doing this? Can you stop doing this, please? And I'm going to turn it over to Sean, because he understands the privacy rights issue and the civil remedies that she was pursuing in the case, and then can explain how the case ended up. It's an unfortunate result at the end, how it was resolved by the Court of Appeal, but that's where I stopped, because that's why I like this panel, because I didn't know what else I could do for her. I'd won the case. What more can I do? I wrote my perfunctory letters to the police, and I'm going to turn it over to Sean to talk about the JN case and the problems with it.
Thanks. Just before I say anything about JN, I mean, you mentioned the vast amount of information which is retained and the fact that it's easily searched. It's also disseminated widely, and this is not a criminal case, but I think it's instructive. I just finished something where a woman about 10 or 15 years ago attempted to commit suicide, and her partner called the police, or called 911, and among others, the police showed up. So there was an occurrence report from this attendance. And literally 11 or 12 years later, she was trying to enter the United States. She was at the airport at Pearson, and the U.S. border agent was aware of this occurrence and refused to let her in because she posed a threat to the health system there. She might impose a burden on their health system. And so it emerged that what had happened is the occurrence report had been uploaded to CPIC, and CPIC shares not all, but almost all of its data with the Department of Homeland Security, which I had not previously been aware of. So you can see how a record not only can sort of cause harm within the police service itself, which retains it, but how widely and easily disseminated they are now. In JN and Durham Police, it was fairly obvious that the judge at first instance was appalled by the fact that this woman who was fairly obviously factually innocent was not going to be able to get a job with the school board. He made an order, he enjoined the police from disseminating this information. But the Court of Appeal got hold of it. The case ultimately founded essentially on procedural grounds. It should have been an application for judicial review to divisional court, but the lawyer had just framed it as an ordinary application. So the judge who afforded relief didn't have jurisdiction, and JN lost and paid a lot of costs on that basis. What did come out, and there was a case that I think John's going to talk about called Tadros a few years earlier, which is roughly similar on the facts. The Court of Appeal did appear to be concerned about the fact that there is no process in place for addressing this with the police service. And to be more specific, some police services, including, as it so happens, the Durham Police, have an ad hoc process where you can write sort of letters that get written, and in the discretion of the police service, have them not release this information when there's a VPC search. But it is, as I say, ad hoc. For one thing, a lot of police services don't have any similar procedure. And in any event, it's very Kafkaesque. And in particular, you don't know what criteria they use to determine whether or not they're going to take you off the list or withhold the information. And you don't know what information is put before them. So you really are fencing in the dark. And so the good thing that I think, the most that can be said on an optimistic note is the Court of Appeal did hold, it dismissed it solely on procedural grounds, and then did comment obiter dicta that there were important questions. I'm just looking at the quote here. There were important questions about whether or not the law requires police services to put in place a process whereby an applicant can seek to have non-conviction information withheld on a search. So I think there is some good, possibly Section 7 law coming our way on the right set of facts, because, as I say, the Court of Appeal did appear to be somewhat troubled by the Kafkaesque nature of what happens when these searches get released.
When we see those facts in that case, we can easily come to the conclusion that saying that JN was a public risk to children was probably foolhardy. What about a case where there is a fair bit more evidence and the accused enters into a peace bond? What about the Tadros situation where Mr. Tadros was charged with 8 counts of sexual abuse and the children and wanted to become a group home worker in Toronto?
The fellow was actually from Cairo, and he had 3 degrees, one a theology degree, one a social work degree, and one a law degree. But apparently he liked children, and as a result he started in his career dealing with disabled children and children with great risk. Came to Canada and opened up a home, 6 kids. And after a time there was allegations, which may have had to do with people paying the right amount of money for things, but in any event he got accused of something. So what happens, of course, is that he signs a peace bond. Now, the peace bond we all thought was the great placebo of criminal law. Well, no longer. Peace bonds are criminal records, let's be clear, okay? They will show up all the time. They will show up on most records checks, and you can't explain the difference to a potential employer. These little mini trials in the back of the police station to try and convince the police you're really a good guy and things shouldn't be revealed are pretty ridiculous. So he signs a peace bond. And of course, what happens then is that he tries to get his license back. Well, they won't even respond to him, nothing at all. So then he, of course, tries to do something else. And he brings an application, essentially, to prevent the police from disseminating this information. And this is the decision he won. Summers, Jay, gave him a Pyrrhic victory, as it turns out. But you'll be interested to listen to this language. The retention and dissemination by the police of the information about the withdrawn charges did not violate the applicant's rights under Section 7. There is no freestanding charter right to dignity, reputation, or freedom from stigma in Canada. Our seminal constitutional document doesn't ensure Canadians should have dignity. That's a ruling. This is the one he won. The applicant's claim for loss of human dignity and self-respect doesn't violate his right to liberty under Section 7, and the Charter does not protect a right to be employed in one's chosen profession or to generate business income by one's chosen means. Nor did continued retention of the use of the records referencing the withdrawn charges violate the presumption of innocence. The presumption of innocence cannot be read as protecting against any adverse opinions or prejudices drawn by individuals or organizations outside the scope of criminal proceedings. So what they said essentially was that he didn't really realize that he was consenting to have these withdrawn charges disseminated, and so his consent to do that was not viable. We now have HR departments, as you know, who are smart. They don't say, do you have a criminal record anymore? They have a 14-page form that says, we want you to consent to us asking the police what they think about you. There's a woman in Ottawa, we've been researching this for our panel. This woman has never been arrested, never been charged, never been questioned by anybody. She does a level 4 check to become a teacher. Some police officer has put on her file she's a known associate of a gangster because she once dated one. She is now rendered unemployable for life as a teacher because some police officer has written an opinion on her level 4 records check. Now, there are some ways around this, but it is really, really offensive. The presumption of guilt in the public mind, of course, is difficult enough. And after you beat the drug recognition expert and you beat the mandatory minimum sentence and you walk your client out the door, you're still never going to the States again for the rest of your life because you have an allegation of drugs on your record. Allegations are enough. You know, I think we started to lose it basically at the bail hearings, and I don't think we've been doing a good enough job. Remember at bail hearings they said credible and trustworthy evidence? The rules of evidence really, really protected our clients from this crap, you know? The mudslinging, he's a bad guy, he doesn't, you know, where are you going to be with him at 12 noon on a Tuesday? Why can't you watch him all the time? And bail changed from bail to becoming house arrest, where somebody was presumed to be evil and a necessity of having him followed around 24/7. The rules of evidence really help us. And when you have a little trial in the back of a police station, well, I didn't really do it, or, you know, you're trying to convince a policeman that you're innocent. Good luck, okay? That's why we have courts. These issues of criminality were decided in courts of law with rules. Well, no longer. At the beginning, at the bail hearing, no rules. At the end, parole. I'm going to talk to you about that, too, just for a second while I have it on my mind. You think you win a case. We won a case, Sam, you and I, a case, a murder case, first-degree murder case. The guy is now going for parole.
Well, on other charges. He's been...
On other charges, completely different charges. He wasn't a good guy, he still isn't. But what they're saying to him is, well, you know, the police officer thinks you won your murder case because you made gang signs at the witnesses. Of course, it had nothing to do with it. In fact, it motivated them to testify even better, frankly. But at the end of the day, he's being denied parole on subsequent drug charges on an acquittal because, well, you got off that one. I mean, we're in a position now, respectfully, where we're not doing a good enough job insisting on privacy rights, insisting on the presumption of innocence. You know, it's not just for court. That's what they say in these cases. Well, the presumption, that's just for court. You know, employers can think whatever they want about you. Well, with the greatest of respect, it's a disaster.
Sean, what if that police officer decision to render the person unemployable by deciding they're a bad person, that they're known criminal associates of gangsters, what if that was done so imprudently and negligently, or in John's example, on a very weak basis of evidentiary record? Would there be ever any civil remedies you could pursue for your client? For that imprudence and negligence, perhaps?
Well, as Tadros and JN can tell you, you know, there's one thing to pursue remedies, it's another thing to get anywhere with them. There would be, I think, you know, JN may well have done better if it weren't for the procedural problems. The Court of Appeals, I said before, indicated at least some sympathy. And I do think there is a change. I'm cautiously optimistic that maybe there'll be a change in the law in that respect, just on straight Section 7 rights. The police can obviously be sued for negligence. Hill and Hamilton Police Service established that a few years back. The plaintiff could also sue for damages, Ward and Vancouver damages, for a breach of the charter rights if you could establish them. The difficulty, though, isn't sort of the negligent either collection of the information, the negligent dissemination of it. It's the fact that the dissemination of material which is obtained perhaps entirely legitimately is disseminated and has this sort of huge half-life, and that there's no process in place. The Privacy Act explicitly permits it, and by definition, if you consent, which you're going to have to do if you want to do a search, you're going to consent to the distribution of the information, well, you've lost all your rights under the Privacy Act, under all the privacy regimes, including the provincial one and MFIPA. So the short answer to the question is, you know, I'm hopeful that maybe there'll be civil remedies available at some point in the future, and perhaps the police services will be backed into setting up some process for dealing with these things. But presently, there's not really very much And at the risk of stating the obvious, you know, remedy and damages, even if you establish negligence or breach of charter rights, that's not really going to do you any good unless the damages are going to be, you know, future income for the rest of your life for the job you've lost.
So going forward in the cases that we realize we're going to win, we see the writings on the wall, this case is going to end in our favor with a withdrawal or a stay or some sort of other non-criminal disposition. How can we set the record as best we can, John? Well, we hear all the time that little debate, well, is the Crown, we're going to have them arraigned and have the charges dismissed, or we're going to let the Crown withdraw? Is it going to be a judicial stay? Is it going to be a Crown stay, a permanent stay? Why does it matter? You're going to walk out of the courtroom, the case is over, John. Why does it matter if the CPIC says dismissed, acquitted, stay of proceedings? Why does that matter? Why should we be raising a stink for one over the other?
Court of Appeal has said that the peace bond is not a win. A peace bond is an admission you are a future danger to somebody. In other words, it's not just a placebo that's going to make the case go away and give somebody comfort and let the Crown Attorney go back to their office without fear of consequences. Peace bond will come up, and you cannot sue if you've signed a peace bond for malicious prosecution or anything else, because you've now made an admission that you're responsible for something or that you're a threat in the future, so that became justified. So you have to be very careful about that, and Scott in his papers put a couple of interesting options on there, which I've used quite successfully. You got a guy, they, oh, give us a peace bond, you know, there's no case, and you think, well, you know, to solve this one, and the client's going to be happy, and maybe he's not going to become a doctor or an engineer or cure cancer. Maybe he's just going to be an ordinary person, not trying to go to the States or whatever. And you have to go through a whole list of questions. But if he is going to be that sort of person, then you can say to the Crown, well, listen, you know, you've got him on bail now on strict conditions, and that's given you some comfort. He hasn't breached that. Why don't we leave him on bail for another 6 months, if necessary, come back and you just withdraw the charges. Then there's no peace bond. Or you come back in 6 months and have an arraignment and no evidence offered. The best case scenario is an acquittal.
Yeah, that's what I want to know. Why is that different?
Because the Court of Appeal says an acquittal is an acquittal for all purposes.
What do we tell a judge who says, what's the difference, Mr. Struthers? What's the difference?
Well, you don't have to enter into a peace bond, obviously.
No,
So,
but on just the withdrawal versus acquittal point.
well, the acquittal point means that, of course, you have an argument to be made with respect to some of these issues that come up in the future. When you go to the little police committee at the back of the room, or you go to the border security. I've got another one which we were going to discuss, if I can throw it in.
Yeah, go ahead. Sure.
I had a young man who's coming into Canada, and he's given me permission to tell you this, coming into Canada to go to engineering school in Ottawa. And he's 18, but he's Arabic. And his dad from the United Arab Emirates had given him a bunch of money for the school year, which he properly declared, but it was cash money. So they went up one side of him, down on the other. And of course, in his cell phone, they found a picture of a girlfriend under 18 in a compromising position, and they charged him with importing child pornography. We got to the Crown Attorney and had a long talk about it, and they withdrew the charges. Great. Fantastic, right? Well, here's my letter from the Canadian Border Services Agency, who have been strip searching him every time he crosses the border now, because this is on, you know, importing child pornography is on the record. The Canadian Border Services Agency will not remove the information concerning the allegations of possession of child pornography from our system, although there were no convictions by police. The importation at the time was prohibited and the seizure remains. The Border Services Agency seizure for the prohibited importation will remain in our system for 7 years from the date of the infraction. I won the case. There was no case, right? So you have to be extraordinarily careful what you admit, and you have to set up the record in court, even with a withdrawal. You know, that great day when the judge turns, he said, well, do you have anything to say about that great withdrawal, Mr. Struthers? And everybody goes, thanks a lot, and you run out the board. No. Put on the record, there was never any prospective conviction. There was never any evidence in this case. The case was absolutely frivolous, should never have been brought. The Crown is doing the right thing today. That, you know, put it on the record, get a transcript of it, and then when the guy's applying for a job somewhere down the line, they say, well, wait a second, he was charged with child pornography 20 years ago. Go, no, yeah, right? Get the judge to say something if you can when there's a withdrawal or an acquittal, because you're actually still on trial for the rest of your life. And you're not going to get a pardon from Mr. Harper, are you? Ever. So, you know, it's horrific. Think of the people that we are disqualifying as engineers, doctors, lawyers, and scientists. You know, the cure for cancer has probably got a possession of marijuana record and will never get a job. Imagine
Pulling all-nighters, it's probably Coke.
Imagine what happened to, you know, if Barack Obama had ever been caught doing those roofies when he was a kid, right? We wouldn't have him as president. He wouldn't be in law school now, right? Because he would never have been forgiven, ever, by this kind of a regime. So protect your record at every opportunity.
Are we going to go to politicians and drug use, John, today?
Well, we have to say today, with the greatest respect, that remember after all those great drug warriors left, that Keith Richards is in town today. And Keith Richards wouldn't have been giving that concert for the blind under the new regime, right?
So there seems to be an attack on privacy. When you talk about the Summers decision that he had no privacy because he did his peace bond in a public courtroom and the police have public duties to disclose things. I want to tell a quick story and then ask Sean a question about privacy and release of information. I had a client who was never arrested on a domestic charge because he was out of the country at the time. His ex-wife had gone in and made a complaint. A police officer had gone to a JP and sworn the information, and there was a return date on a summons that they were going to serve to him when he got back. And the police ended up talking about it, going to a Crown and saying, boy, this case is complete garbage. Just go withdraw it before we even charge him. So they go into the JP court the next morning and pull the information. So the clerk writes on it, withdrawn by Crown. But it had gone to CPIC. And my client was an engineer on his way to Mexico to do some work, and he got stopped in Dallas with all his colleagues. And they detained him for hours and called him a domestic abuser. And of course, he played dumb because he didn't even know he'd even been charged. He'd never even heard the notion that he was being complained about. And the U.S., we talk about the U.S. The U.S. has a tremendous power to grab and seize all the CPIC information. So when I was the next week able to convince the staff sergeant in St. Thomas to take it off CPIC, which she did, the U.S. had already grabbed it. The U.S. had already pulled it into their system, and they have a file on every single one of us who's ever entered their borders. So he still is nervous going through customs each time. I've written him a letter that says I was his lawyer. He never was even arrested on this, and he's said it's been okay. But one of the things we wanted to know was, what was her complaint? What is this complaint? He never was arrested, no disclosure. So I wrote to the staff sergeant again and said, can I have the brief, please? And she said, no, you'll have to make an FOI request. So they seem very keen to disclose things when it's according to some other agenda, but when he wants to have transparency into why he was completely embarrassed in front of his colleagues, luckily some of them knew his ex-wife, so they weren't too, but why am I being referred to FOI requests, Sean, when it's my client's disclosure, and when they seem to be so willing to disclose it in other arenas?
Well, it is actually, because they can't disclose it. I mean, it is actually caught by MFIPA, and they can't disclose it if it's going to disclose personal information about anyone else, i.e. the wife, without her consent, or unless they can come in within an MFIPA exception. So,
Municipal Freedom of
Municipal Freedom and Information and Privacy Act or something like that.
MFIPA.
But just to back up for a second, the Court of Appeal actually did say in a case called Mamalidi and Niagara Police Service that a peace bond is not necessarily fatal to a malicious prosecution suit. And in any event, so that law, the earlier law in Beardsley that John was referring to has been, I would say, more than cast into doubt. I'd say it's not good law anymore. But having said that, it seems to me that no responsible criminal lawyer is going to plan an appropriate approach and advise their client about a peace bond or not a peace bond, or pleading guilty or not pleading guilty, on the basis of the civil lawsuit that's coming later. I sometimes get calls from people who are still facing charges, and I won't talk to them. I say, just listen to your criminal lawyer and we'll deal with the civil suit after the fact. It does seem to me, as I say, that FOI is usually a useless remedy in any event, and that your clients really have, I think it's important for them to know that this non-conviction is going to have a long afterlife, and they may, depending on the strength of their case, need to go through for the acquittal and for the vindicating reasons from the trial judge. And it may affect their risk tolerance for some sort of deal as opposed to going to trial. But beyond that, I think there's very little that criminal counsel can do, other than make clients aware of what's going to happen. And the civil remedies just have to be pursued after the fact.
So how helpful do you think a trial judge saying, in a case that ends as well as you could imagine, I believe the accused, the Crown's case, either way fell very short of the standard of proof, and I find him completely not guilty. How much does that help you compared to just a withdrawal?
Well, that would be great. I mean, that would provide massive assistance, I imagine. If nothing else, you could just hand it over with the VPC search at the same time as you're applying for the job. But that's fantasy land. And if your case is that strong, then the Crown's probably going to pull the charges in any event. So, most people, I expect, I mean, I would defer to everyone in this room, but I mean, most accused persons find themselves in a far more precarious position. Which is what the Court of Appeal recognized in Mammalady and Niagara Police Service. They said, obviously, the Crown has immense bargaining strength, and just because you do something expedient like sign a peace bond doesn't mean that you can't later sue for malicious prosecution.
There's a couple of other things that you can do with your client, and you can tell them, unlike some people, to get in front of the problem, which means that if you have something on your blot, the stigma on your record, and you're applying for a job, get ahead of it. Put a whole package together with the employer, for that matter, or whatever the case may be from your lawyer, to explain yourself in advance, because it's going to come out. You're not going to be able to hide it. The HR departments are very tricky now. They're essentially asking for the police opinion of you. Well, I've had clients in that situation. They don't really need a level 4 check, but the employer's demanding it. I say, go to the station and get a criminal records check. Just a regular criminal records check. The one that used to come up and say, no convictions, right? When they ask you for that, say, I've already done that, here it is. If they aren't satisfied with that, well, tough luck, right? I mean, there's lots of things that you can do to sort of get around it, but you have to get ahead of the issue, because right now, these things are going to be disclosed, and it's really quite political. People who are even accused of criminal offenses now are sausages. We listen to the prison industrial complex warnings, rumblings coming from the South, and our current government is on that track. If you are accused of something, you are no longer human. You are a sausage in the system, so you will forever be a sausage. You cannot escape, even if you are found not guilty, without extreme preparation. And, of course, joining the Canadian Civil Liberties Association and doing other things to actually become political about it, because it's really inappropriate what's going on.
We talked about the not getting the disclosure in my case. How do you deal with these things, Sean, when they come up later on in litigation, say family or child protection, or a wrongful dismissal allegation, or wrongful dismissal suit where there was an allegation of criminality that didn't lead to criminal charges? How do you deal with what documents and what disclosure you pursue, and what can criminal lawyers be doing to create a better record for you, Sean, to give the client the best civil remedies in family or employment or other lawsuits?
Well, conducting a trial which results in the vindication by the trial judge is always good, but as I was saying before, unrealistic. Apart from that, keeping some sort of record, or the best record one can, of the concessions by the Crown or police at the time. The problem with recording this sort of concession is that you may find that Crown and police aren't very likely to engage in frank conversations with you after you've done it to them once, sent a confirming letter. But really all you can do is make a record as best you can of the concessions that are made at the time. And then the client is left with the prospect of, getting the documents and sort of reproving the innocence, as it were, in the civil proceeding, which is very expensive, and for most people, most middle-class people, exposes them to costs if they are unsuccessful in litigation, which is a risk that most middle-class people can't take. I mean, in order to engage in civil litigation in Ontario, you either have to be judgment-proof and not care about a cost order against you, or you have to be really very, very wealthy, because even the simplest 2 or 3 day trial will result in a cost order against the loser, well in excess of $100,000, which would wipe out most people in Ontario with any assets.
I think we can all imagine a case where you bring, let's say, an 11B or another kind of charter application that will end the case, either excluding a statement perhaps, or the fruits of a search warrant. And when the trial judge comes to his 24-2 analysis, he's going to talk about how serious these charges are, how strong the Crown's case was, but on margin Struthers was very charming, and I'm going to exclude the evidence or grant the 11B. Would you ever not bring that application and go for the straight acquittal if you had evidence of it?
Probably not. I mean, if I've got a really strong 11B or charter application, I'm going to bring it. But you're right. I mean, if you have on the merits the best case ever, and your client is trying to be a doctor in the future, you might want to just get to the merits
That's
of
what
the
I
case,
mean.
right? That's what
Because
you're
if the
saying.
case ends with, this is a serious case the Crown could have proven easily, but I'm going to stay it anyway, how does that help you going forward?
Well, that obviously you have to discuss with your client what his eventual goals are, and that has to include the fact that the case isn't going to end no matter what happens in court. It really isn't.
So going forward, I'm putting forward a couple of ideas. When you have, and I say young people, especially people in their early 20s that haven't quite figured out what they want to do, in your initial interview, find out their futures, what they want to do, because I think it will make a difference. Because, like I mentioned, chicken catchers and tradesmen, you know, a suspended sentence, I don't see preventing them from getting employment. And if the Crown's going to be asking for jail for some other reason after trial, or if there's not a quick plea, you may be able to counsel that client, yeah, take the suspenders, take the conditional discharge. It's a good result on these facts, and you've done your due diligence with counseling them into the plea. But if he's going to, you know, get a BA, and he mentions wanting to be a teacher,
Or a mayor.
You might want to consider very strongly finding another creative way to dispose of this charge that doesn't involve any kind of court process, including peace bonds. So John mentioned before the long adjournment, if there was some suggestion that a cooling off period is going to assuage the Crown's concerns. The other one I've come up with that I was given by an old lawyer in Barrie who suggested it to me off the cuff once, and I've used it a few times since, is offer the Crown a trespass notice under the Trespass Act. If this neighbor dispute is so simmering, and your complainant's going to want some kind of court process, well, I will accept service of a trespass notice. All it has to be is in writing. It could be on a cocktail napkin. And under the Trespass Act, you can then tell your client you can't go there. And it's just a way to keep it out of with any sort of criminal mention. We all know the 810 says criminal code, section 810. You show that to an employer and try and tell them it's not a criminal record.
And the cases do say that an 810 of necessity is a finding of future threat risk. It's not something to, you know, go to what's already happened. You, as of today, pose a significant future threat. That's what you have to have. And without that, they really shouldn't be entered into.
So Crowns will offer you those peace bonds, and they think they're being very generous to you. But if in the right case, when it's worth the fight, say to them, look, the standard in the criminal code is future harm. You're telling me that a complainant or a police officer is going to depose in a new information that they believe on reasonable grounds that this complainant fears your client. Well, if it was a bar fight at the docks a year ago and they don't know each other, I just don't think that's true. I don't think that document should be sworn. I don't think there's a legitimate fear of future harm, and I think you should stand on that principle to turn it down. There is no ongoing problem with these two blokes. They don't know each other. You have reason to withdraw for other reasons. The case is weak, for instance. You don't want to prosecute it. Just plain withdraw and stand on that. And you don't have to take the peace bond just because it's easy.
And let's remember the other option, because, you know, I say this too often, that I used to be a trial lawyer and I'm a pretrial lawyer. The story here is go to trial, right? Make them prove it. Get found not guilty, because that's the best result that you're going to get for a client. Even better than a withdrawal most times. Go to trial. And if we take all these drug cases to trial, you know, all this talk about passing a joint at a university, which is a school, is a 2-year mandatory minimum. With the greatest of respect, they don't have time for that. If we all just take them to trial, remember now, 5% of things go to trial. If we take it to 7%, we've just upped the trial ratio by 40%. The system can't handle 40%. Our biggest asset is the fact that we can say, prove it. And we need to do that a whole lot more.
We have about 6 minutes left, I think, so we're happy to take questions.
Dan?
Yeah, I just have a question. You know, you're talking about taking things to trial, and let's say ultimately you get the ultimate result, which is an acquittal. My huge concern, and I've been listening very carefully to see if there is, on the civil context, some remedy to this. And obviously, you're not looking to this to get a remedy. You're looking at it to prevent the disclosure of incredibly damaging information that prevents employment, et cetera, et cetera. But even if you get an acquittal, I mean, I have clients who, while they are awaiting their trial, they are presumed innocent, they're on a bail, they ask for, an employer asks for a record check, and it's released that they've been on bail. And frankly, my understanding in many cases is regardless of the acquittal, the information of having been charged will be released. Right. So literally, there is nothing, as I understand it, once you've been charged, to prevent the police from disseminating that information, even if there's even if the judge were to say, I find you factually innocent, the complainant is a horrendous, compulsive liar, etc., it doesn't matter. So can you help me out? Is there some way to address this insane unfairness?
You're completely right. It's not a good situation, but believe it or not, that's the best one. That's the best situation, because then you could say, I was tried where we're supposed to be with rules, evidence in a court, and found not guilty. And you're a Canadian. You're supposed to believe in the presumption of innocence. I didn't do it. The judge found I didn't do it. The jury found I didn't do it. And now, these 14 other guys with the resumes that don't have that on it, they're not going to get the job. Give it to me. Right. Good luck.
Jeff?
Oh, yes, thanks. Yes, you mentioned the evils of the Section 810 peace bond. I'm just wondering if you've discovered any difference in practice in terms of prejudice to the client for a common law peace bond.
No.
No, and for instance, on the firearms application form, it asks about both to be disclosed.
Right.
No, there's no difference. They both end up on CPIC. They're both
Okay, so
there.
the fact that one says criminal code and the other one doesn't.
That's just a.
The only reason the Crown's like it is because there's a specific enforcement section for 810s as opposed to just breaching court order. That's the only difference, that there's a specific enforcement
Right,
section.
and it's debatable if common law can even be enforced. Sorry.
Yeah. Craig, we have an online question?
I have an online question from Mark Gottlieb asking, do you guys know if any Canadian civil liberties associations are banding together to take a facts and a situation to the Supreme Court of Canada to resolve these issues in accordance with the rule of law?
There is a case in the Supreme Court. It's an employment matter, not a criminal law matter, but involves privacy rights, and the CCLA has intervened, and that's being argued in about 2 weeks. The CCLA has also published the paper that's mentioned in the paper, and it's very keenly interested in the issue, and I think it's looking for the right set of facts. And it was the CCLA referred the one I was talking about, the woman who attempted to commit suicide and got stopped at the border. They referred that to me. So they are all over the issue, but at present we're still waiting to make some law. It doesn't exist.
Terrific paper. The CCLA
Yeah,
paper is terrific.
it's chilling.
Chilling.
Right. John?
Yes, thanks. So just to follow up on that question, the CCLA did intervene in the JN case and were very helpful in the JN cases. And the CCLA has an ongoing interest in this issue and would be keen and eager to participate in any case if anyone were to bring it, for example, for judicial review. I want to echo everything everybody said. I don't have a question, but just a few more practical tips if I can add.
Yeah, please, John.
John was counsel on the JN application. So.
Yes, I'm the one who doesn't know the difference between an application and a judicial review, apparently. So a couple things you actually.
Either way, you know that, right?
Yeah, I know. I would have liked to have lose on substance, the procedure, but that's okay. In any event, a couple things you can do. Once you have a client who has been acquitted or charges withdrawn or stayed, in addition to at some point contacting the local police jurisdiction, Toronto, Durham, whatever it may be, to ask for a destruction of the file and a destruction of the fingerprints and photographs, you should also be writing to the RCMP. The sergeant who runs the RCMP database is very interested and very concerned about this issue, and at a conference that I was at some time ago, complained about the absence of requests from defense counsel to purge the information that the RCMP actually holds in CPIC, and they're quite keen to purge particularly outdated information. So you should be, on behalf of your clients, once you've achieved this fabulous result, contacting both the local police force and the RCMP to ask for a purge of all information, and they may very well be responsive to that. If they are not responsive to that, you should know as a result of JN and a few other cases that the Ontario Association of Chiefs of Police has now issued a directive trying to set out, it's not even close to where it needs to be, but a series of criteria that should be considered when somebody makes a request to have their non-conviction information purged. So if you are trying to make an argument to a local police force about at least what criteria they should be looking at, you should go to the Ontario Association of Chiefs of Police website. I can't remember the name of the document off the top of my head, forgive me, it's been a while since I looked, but look at the website and the document is there and that's helpful. Some individual police forces, as a result of JN and some of the other issues, have started to engage a much more robust procedure in terms of being able to review in a somewhat more transparent procedure. Again, there's a long way to go, but for example, York Regional Police has a fairly robust review procedure, but it needs to be engaged by the client or the lawyer on behalf of the client. So if you have one of these cases, you should be immediately contacting the police force that holds the information and asking them in their records department what the process is in order to purge this information, and some of them are actually quite helpful. The last practical tip, and I'm sorry to take up so much time, the last practical tip is there seems to be some gap in certain cases between the local police force and what non-conviction information they retain versus the police force in the next jurisdiction. So sometimes if you have a client who had some difficulties, likely not criminal, but an apprehension under the Mental Health Act or a child abuse complaint that may appear, for example, on the York Regional Police Vulnerable Sector Check, there's a question about whether that information necessarily made it to Toronto or to Durham. Now, if it's criminal, it likely has made it onto, almost certainly made it onto CPIC and is covered everywhere, but not the non-criminal stuff, and tragically, that's also capturing people. So you should consider, if your client comes to you and says, I went to York Region and my vulnerable sector check has come back positive, you may want to consider sending that client to Toronto or Durham or somewhere else and saying, get your vulnerable sector check from them and see if you have to give that to your placement coordinator or your prospective employer, whether that record may actually be clear. So I hope those are a few practical tips.
This is all in the
great panel.
This is all in the name of public safety, of course, so I can't help but leave you with Benjamin Franklin. Those who give up the essential liberty to buy a little temporary safety deserve neither liberty nor safety.
I'll leave you with one more thing. We talked about how these criminal records can affect your ability to get a job, to travel, and get firearms. They do not affect your ability to join the Army. So, thanks very much.
Thank you.